My name is Søren Avi, and I am an assistant professor of criminal law at the University of Aarhus in Denmark. And I'm very happy to be here at the European University in Tbilisi to present some of my recent research on EU criminal law. I've just given a public lecture, and now I'm going to address some of the same topics. And the overall thing I want to talk about is the question of how should the EU use its criminal powers. Of course, with the Treaty of Lisbon from 2009, for the first time, the EU was conferred with supranational criminal law powers, meaning that the pillar structure was abandoned and the EU got its own real criminal law competence. And in relation to substantive criminal law, this competence can be found in Article 83 TFEU, which entails two provisions, the Eurocrimes provision and then the more functional competence provision in 83.2. So of course these are the treaty limitations or the treaty conferral of competences on the Union. And these are of course subject to the constitutional limits that the European Union is always subject to, meaning that of course the Union only has the competences which has been conferred upon it by the member states, and competences that have not been conferred upon the Union, they rest with the member states. And I guess this is particularly important when we're talking about criminal law, because criminal law has, at least historically, been intrinsically linked to the concept of the nation state. I'm not the person who made up this link. This is a link that goes far back. You see the Bundesverfassungsgericht, the German Constitutional Court, held in its famous Lisbon judgment that there is like this special connection between being a nation state and having the powers to determine which conduct is criminal and which is not. And we also see that every time the EU steps into the field of criminal law powers, member states react a little bit. We saw it in the Brexit debate where there was some anxiety about whether EU criminal law would interfere with like British common law traditions. And we've also seen it in the Nordic countries where there has been an anxiety of over-criminalization. Would EU criminal law lead to more repression and thereby to the abandonment of the Punic exception or Punic exceptionalism, which has ruled the Nordic countries' criminal law systems since the 70s. And I guess these are some of the worries that has also led to the existence of the Danish opt-out, which for me, of course, as a Dane, is a particularly interesting subject. Well, so it's against this backdrop of ever respecting national sovereignty that the EU criminal law powers have developed and gotten to its, like the state of the art right now, the Lisbon Treaty powers. So when we look at Article 83.1, we see that the EU has the power to adopt criminal law measures in areas of particularly serious crimes if they entail a cross-border dimension, either from the very nature of the crime itself or from a need to combat this crime on a common basis. So, of course, some crimes are by their very nature cross-border. That would be, for example, human trafficking. Human trafficking is something that happens across borders, while other crimes are a little bit more difficult. You might say some sort of illicit arms trafficking cross-border by nature, but maybe some sort of computer crimes are more not cross-border by nature. But if the free market and the free movement is to actually function effectively, then we need to have a way to combat, like a common approach to combating, for example, some types of computer crime. So these are the first two requirements, and then we have the third requirement that it should be one of the areas of crime included in the Eurocrimes list. And here we have 10 areas of crimes, which you can look up, but it's like sexual exploitation of women and children, computer crimes, organized crime, illicit drugs trafficking, etc. And this list of crime can be extended by a unanimous council decision, which we saw happen with the sanctions against Russia, where the council decided that now breach or violations of EU restrictive measures against Russia is now a Eurocrime. So we have 11 Eurocrimes now. Great. So now we know what the competences are, like the competence limits. When can the EU enact substantive criminal law? What we have not answered yet is when should the EU enact these powers? And this is, of course, a much more difficult question because here the lines between legal theory, law, and politics gets kind of blurred. Like, when should the EU enact criminal law powers is first and foremost a political question for the EU institutions to resolve. Nevertheless, we've seen that criminal law scholars have tried to attribute some theory or like some guidelines in this field. We saw this early on with the EU Criminal Law Policy Manifesto from 2009 already, where they said, of course, fundamental criminal law principles as the ultima ratio, the legality principle, the principle of guilt should be respected when the EU drafts criminal legislation, because you can't just have member states have these strong Rechtsstaat traditions and then the EU doing something completely different. So, of course, EU criminal law needs to be in line with the traditions of the member states. And that, I think, is fairly obvious today, and you can discuss how well it's being respected. But overall, I think it is respected in the proposals that we see from the Commission. But then what I wanted to touch a little bit about also is like, could there be some cases where the EU must or should actually use its criminal law powers? Are there cases where the EU have positive obligation, where the EU legislator needs to use criminal law powers? And my answer to that would be yes, I think there might be. If we look at the European Charter of Fundamental Rights, then we know, of course, that the right to privacy is a part of the Charter. The right not to be subject to degrading or inhuman treatment or torture is a part of the Charter. Equality between men and women is a part of the Charter. In these areas, I would say maybe there would even be a positive obligation to secure and defend these rights using criminal law means, if it falls within the competence of the Union. And you might think, is this just something he made up? And maybe it is something I just made up, but I think it has some support in the Charter, Article 52.3, where it says that the meaning and scope of the Charter is the same as the meaning and scope of the European Convention of Human Rights, at least. So the minimum protection in the Charter has to correspond to the minimum protection in the ECHR. Okay, we ask ourselves. If we look at the case law of the ECHR, the European Court of Human Rights, then we know states have an obligation to protect victims of rape or sexual violence. They have a positive obligation to do this. We know this from MCV Bulgaria. We know it from Daugaard and Sørensen v. Denmark. We have a positive obligation. States have a positive obligation to protect citizens against murder, their right to life. We know this already back from the Osman v. the UK case. States have a positive obligations even to protect its citizens against environmental disasters, which can lead to the loss of life. We know this from Yonarildis v. Turkey. So all these positive obligations which are in the ECHR, logically, they must also be in the Charter, since the Charter corresponds to the ECHR. So if you follow this logic through, then the cases where the EU, like EU legislation, should in some cases not just be a political question, do we want criminal law here or not? Is it in line with the fundamental principles of ultima ratio, etc., but also a political obligation for the EU legislators to actually make criminal legislation to defend the rights in the Charter, and an actual legal, doctrinally based positive obligation, I would argue.